Well, firstly, let me say thank you for all your lovely welcome back messages in the comments. That's really appreciated because I have missed you and I have missed doing these videos. But somebody also raised in the comments, they said, could you speak about the recent Barton and Vine judgment? And yes, I can, because it gives me a chance to do my Mystic Owl thing. So first of all, I'll go, ooh. Just a further update on the Vine and Barton matter. Some people have pointed out that Mr. Barton also made another tweet. The tweet being words to the effect of, if you see this person near a school, call 999. Now that actually might be a bit of a game changer. Because, as I said in the previous video, you've got the mere vulgar abuse. Because of appending the word bike to the front, he had an argument about this is just an insult to do with Mr. Vine's sort of, being very much into bicycles. However, that phraseology, if we apply that meaning test, what would your average person think about that? Well, what would you think if you heard somebody say, oh, it shouldn't be near schools? You're more likely to think that is an accusation of the P word. So it'll go for the meaning hearing, and as I've said, I think this case, if it gets to the meaning hearing, that will be determinative, because if the judge says, yeah, actually I do accept this is just mere vulgar abuse, that's the end of it for the claim. If, however, he says, no, I find this an accusation of the P word, I think Mr. Barton's in trouble. And now we're back. So, what was all this about? As you may know, Mr. Barton on Twitter made certain allegations about Mr. Vine. He would say in a disparaging, joking manner, not to be taken seriously. But he used the phrase, it rhymes with, what does it rhyme with? I'm trying to think of a word it rhymes with that isn't also something that YouTube wouldn't like. I'll say once. So he called somebody, he said he was a bike once. But he also made certain other comments, including this is not somebody who should be safe near schools. Also that he was a defender of the P word and people who had committed the P word or were P words. And Mr. Vine sued. He sued for defamation and also misuse of private information. So what's the first thing that happens in a defamation case? Well, we have a hearing to determine meaning, the meaning of the phrases. And we have what we call a single meaning rule here. So when you're arguing, the claimant will say, well, this clearly means it's a serious allegation and it's to be taken seriously, and it's alleging that I am in fact a P word and that I support P words and people who are guilty of P words. Whereas Mr. Barton said, this is clearly what we call mere vulgar abuse. Sometimes we say mere vulgar abuse is a defence. Technically it's not a defence, it's just arguing about the interpretation of the words. But it doesn't matter what the parties themselves argue the words mean. An intention is irrelevant. A judge decides what the single meaning of those words are. In the old days, you just left it to a jury. But now judges can also find facts. They're not just there to decide the law, which does actually help. This is why so many defamation cases settle. Because once the judge says, well, I don't care what you say or what you say, I say it means this. What is the test? The test is that what would your average hypothetical reasonable person, who's not unduly suspicious but not unduly naive, at first instance they have a read of this, what would they think it meant? And they just look at what you would have seen. People always argue, well, you need to know the context of this. But unless the context is sort of self-contained within the statement, people might link a screenshot or they might link to a separate story, then you just take it at face value. The mere fact that actually you could, if you read into the history of this, you'd see that they've always been having spats backwards and forwards, and it's clearly just them having a dig at each other. Judges say no, unless it's a fact that is so notorious that everybody would know it. Sometimes we call that judicial notice. Sometimes you don't have to evidence things. You just say, come on, judge, everybody knows this. The example they gave in this case was that, everybody knows that the Conservatives won the 2015 election. Now, I personally wouldn't have known that because I'm so out of touch. I'd have gone, what year was it? But that was an example they gave. So in this particular case, As predicted, the judge said, well, the bike once thing was clear vulgar abuse. However, the other allegations were allegations of, of fact. You weren't just saying this is just, abuse. You were sort of putting it forward as if this is a guy who is a P word and who defends P word people. So the judge found that. Now, the single meaning rule, because people say, well, actually, lots of people would have realised this was just a joke. The single meaning rule has been criticised. I mean, we don't have it in malicious falsehood. In malicious falsehood, if you can argue and say, I don't care what they're saying, enough reasonable people would agree with my interpretation, that's fine. I mean, they did try, in a case, to try to introduce the single meaning rule into malicious falsehood, and the court said no. And they actually said, let's face it, if we were starting defamation from scratch, there'd be no justification for having this single meaning rule. It's completely artificial, and it just produces silly results. But now Mr. Barton is stuck with this. So the judge has found there were 14 offending tweets. And like I say, the judge said all the ones that just say bike ons, yeah, that's just mere vulgar abuse. I'm not going to take those seriously. But the other ones I am. So now what happens? Well, theoretically it progresses to trial because there's still the misuse of private information stuff to settle. But what does Barton do now? I mean, his only defences are to argue it hasn't caused serious harm. But the problem is, when you allege criminality about people, as I've said in another video, if you're alleging that they're guilty of an offence that can attract a sentence of 12 months or more, that is usually deemed to tend to cause serious harm. Oops, did something just turn off there? Oh no, it's still going. Oh no, there's a bird tweeting. Sorry, I thought it was the camera turning off. Hello, little birdie. Hello. Oh, look at this. A little bit of nature for you, just there. Can you see him? So this will now theoretically progress to trial, but will it? My prediction, doing another one of my predictions, is no, it won't. Now, as it happens, I know the people who are representing Mr. Vine. Hello, Gervais and Judith. Just give you a shout out. They're highly competent people. As indeed are Barton's lawyers. So they will be advising him now, saying, well, look, you probably don't have a defence to this. You're not going to allege that it's true. You can't really argue any sort of public interest defence. It's not in the public interest to spread lies about people. So what's Barton likely to do? Well, he's fairly stuffed on this, really, because he can't really argue it's true. He can't argue it's in the public interest because, it's not in the public interest to spread lies about people. So I can't actually see of any possible defences. So he's probably going to have to throw the towel in. So I suspect there's going to be lots of negotiation backwards and forwards now about, levels of damages and costs. We might also get what we call a statement in open court. A statement in open court is something that's a way of settling defamation cases, where you say, okay, we'll pay you some money. But also, in order to reduce the damages a bit, we will do a bit of a mea culpa. We'll fall on our sword. So counsel for each side turn up in court. And usually it's actually the defendant's counsel who will read out and say, we're really, really sorry this happened, apologise, we accept it was all untrue, we will spread this, sometimes they'll say, you've got to publicise this. If you were putting this out, the allegation was on Twitter, they might say you've got to tweet this and link to your statement in open court. If you've got a website, they might say that. I mean, sometimes, I must confess, sometimes you just let the claimant's lawyer read it out and then the defendants will say, oh yeah, okay, yeah, we agree with all that, we accept all that. So it wouldn't surprise me if that happens. Of course, it may be that Barton sticks to his guns and says, no, I'll see this all the way to trial. The problem there is what's going to happen with damages. Because in this country, we don't have punitive damages as such, like they do in the US. Damages are meant to be purely compensatory. So it's like, okay, you were insulted, but this amount of money will put you back in the position as if you weren't insulted. So the idea is that you go, well, I'm not glad I was insulted because of all this money I've just got in, but also I'm not too upset about it now because this makes it right. I mean, it's very artificial, but we do this for personal injury claims. I mean, I'm sure most people would say, I'd rather still have my arm or my leg than any amount of money. But we put a monetary value on it, and that's what we do in defamation. So yeah, so that's what I suspect will happen now. There'll be lots of negotiations in the background. But the trouble is, if Barton sticks to his guns on this, then the court might say, okay, you're getting the regular damages, but we're also going to give you aggravated damages because when he realised he should have thrown the towel in, he effectively, kept doing it. So, like I say, it's not punitive damages. The argument is that by continually, hinting that this is true, or you're going to fight it, so you're hinting that this was justified, then that causes more harm, so there should be more damages. So there you go. Right, as always, hope you found that vaguely useful, vaguely interesting, vaguely accurate. Where am I today? I'm at St Clement Church, which is a lovely, lovely spot. And I'm next to this wonderful standing stone, which I suspect is an old Neolithic one that was repurposed in the Christian era. But it's quite interesting because it's got both Latin inscription on it, and it's also got what we call Ogham down the side. So it's a very old script there. So it's very archaeologically interesting. But there you go. Like I say, thanks for the welcome back, and thanks for the very useful comments that gave me something to talk about. And thanks for that sparrow for jumping in.